Welcome to the NCDWI Guy podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI Guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 267 of the NCDWI Guy podcast. Today we are talking about a recent North Carolina Court of Appeals decision, State versus Holt. This was released or filed on May 20th of this year. Landmark North Carolina case interpreting the confrontation clause in the context of blood analysis and expert testimony, very much piggybacking off of the United States Supreme Court's recent decision of Smith versus Arizona. So we're going to talk through this decision. This decision came at kind of a important personal professional time on my end, because the day that this case was decided, I was driving to Madison County, or the opinion was released. I was driving to Madison County to argue a case that involved a drug blood analysis. Now, ultimately in that case, the analyst was not subpoenaed or present in court, and the state proceeded without the blood. But I was gearing up to have an argument about potential substitute analyst testimony. And so I went back and listened to episode 259. And if you're listening to today's episode, go back and listen to episode 259. That was substitute analyst testimony with Justin Philbeck. Justin has done a comprehensive deep dive and research on this issue. We talked about that in light of the Smith versus Arizona decision. So go back and listen to that episode with Justin Philbeck. He walks through the North Carolina cases that are kind of on point leading up to this, as well as the United States Supreme Court decisions in this arena. But Justin kind of said, we're still a little bit in the mud and in the murk. And I would say that State versus Holt very much clears this issue up for us. And really, I would say Justin kind of predicted the kind of issues that the court would need to address on substitute analyst testimony. But go back and listen to episode 259. So I was headed up to Madison County, ready to argue this case. And as I'm sitting there explaining my case to a colleague, Mr. Andrew Banzoff, professor, as we call him, Andrew Banzoff, Andy shares with me that this case has been released today. So at that point, hey Jake, the North Carolina Court of Appeals just released this case. Andy was just awarded at the NCAJ convention the Thurgood Marshall Award. Very much deserved. An absolute amazing human being, somebody that is a person that goes to war for his clients, is more than happy to share his knowledge with the criminal defense bar, and has I'm the recipient of a lot of his insights regarding DWI cases over the years, and really appreciate the freedom of which he gives away his knowledge. And so very much thank Andy for pointing this case out. But this case really is, to me, the nail in the coffin of substitute analyst testimony when it comes to blood cases. If you don't have the analyst that performed the blood analysis under State versus Holt or after State versus Holt, I feel like the state is going to have an extremely uphill battle in getting that lab report or surrogate or substitute analyst testimony into evidence. So let's go through the State versus Holt opinion. Again, this was filed May 20th of 2026. The Court of Appeals number is 25-560, and I won't get too deep into the facts of this particular arrest. Mr. Holt is arrested for DWI. Ultimately, after refusing breath testing, the officer involved gets a search warrant to have blood drawn. Blood is taken and sent to the Wake City County Bureau of Identification for testing. A analyst by the name of Irvin Alcox, and now I'm going to read for a second from the opinion, completed defendant's blood testing using the gas chromatography method and determined the alcohol concentration was 0.15 grams per 100 milliliters of blood. Dr. Richard Wagner, who also works for the CCBI in the DWI blood chemistry unit, performed a technical and administrative review of Alcox's work. In performing both administrative and technical reviews, Dr. Wagner reviewed the data and notes to ensure that all the CCBI laboratory and CCBI main procedures and policies were followed. Confirmed the CCBI laboratory request header information was appropriately placed, checked for spelling, typographical, mathematical, and clerical errors, and made sure the information within the lab report, especially the results, was supported by the underlying data. So, analyst Alcox does the actual testing of the blood. Dr. Wagner reviews that testing, and my understanding is that Dr. Wagner did the review of testing prior to the case being called for trial. So Dr. Wagner is actually kind of the one in real time as the blood is being tested at the lab, doing the kind of administrative review, the second check, so to speak, of the analysis. And I think that's important because to me, that would be a stronger argument for the state in saying, well, this particular analyst should be allowed because it's not as though he was completely, uninvolved with the testing from the get-go. He actually did an administrative review in real time as it was kind of being tested prior to the case being called for trial. So he's not stepping in at the 11th hour at the lab while Alcox was still working there. He is looking over his shoulder to make sure that the report was appropriately produced and that the results matched up with the actual alcohol concentration matched up with Alcox's findings. So he's kind of doing this over-the-shoulder review in real time. Now, he's not actually watching Alcox as he's performing blood testing, as we'll later find out, but he is reviewing Alcox's paperwork at the time that he had done the analysis and actually produced his report. At some point, the case goes to trial in Superior Court after a district court conviction. At that trial, the state did not call Alcox to testify as he had retired from the Wake CCBI in March 2020. In his testimony, Dr. Wagner acknowledged he did not perform the analysis on this case and was not involved in the testing or the receipt of evidence. Dr. Wagner testified the following, and this is extremely critical. So this is from the opinion. This is the crux of the issue for cases where the state is trying to proceed with a substitute analyst. Dr. Wagner testified the following could have presented possible problems in Alcox's testing, but he personally did not have the opportunity to check for these matters: clotting, fermentation, the sample's packaging, vial leaks, the blood volume, homogeneity and pipetted bubbles. Additionally, Dr. Wagner testified clotting and fermentation of the sample have the potential to produce artificially high alcohol levels. So in a case that goes to trial where the state is trying to proceed by substitute analysis, these would be, kind of a list of cross-examination questions. Did you have the opportunity to inspect my client's blood for clotting? Did you have the opportunity to inspect my client's blood for fermentation? Did you have the opportunity to inspect my client's blood sample packaging? Did you have the opportunity to look at vial leaks, to check the blood volume, to look into homogeneity and see if there was pipetted bubbles? Furthermore, wouldn't clotting and fermentation have potentially produced artificially high alcohol levels? All of these are kind of then given to us in terms of here's what you want to focus on in terms of cross-examination. So Dr. Wagner says, I didn't have a chance to look at the blood. I don't know what the blood looked like at the time that the testing was performed. Didn't have a chance to review that. So again, those are all major concerns in terms of whether or not there's a potential for an artificially high alcohol concentration. At Superior Court, and this was important to the ruling in this case, which was to send the case back for a new trial, because one thing that and we'll get into why the court, it's a pretty slam dunk case, I would say, in terms of saying this substitute analyst testimony is not going to be allowed in this case. But upon finding that the substitute analyst testimony should not have been allowed, and the report itself, which was introduced into evidence as an exhibit, should not be considered and was wrongly introduced into evidence, the question then becomes, generally speaking, in appeals cases, did this prejudice the result? Did it, cause basically a problem that was harmful error, or was it harmless error? And so the court found in this case it was not harmless error, because the jury in State versus Holt at the Superior Court level convicted solely on the theory that at the time of driving, the defendant had consumed a sufficient quantity of alcohol that he had an alcohol concentration of 0.08 or more. So there was no conviction based on a theory of appreciable impairment. It was solely based on the numeric result. And the Court of Appeals rightly looks at it and says, well, if the number coming from the lab and from the substitute analyst should not have been admitted into evidence, then new trial is necessary, because the sole theory of the case for the jury to convict was on 0.08. So the analysis, I think, is in all honesty relatively straightforward, and you can kind of see this in Smith versus Arizona. But again, I think we've had some murky waters, so to speak, in terms of how to handle substitute analyst testimony. I think State versus Holt very much clears those issues up. So, in the opinion, the Court of Appeals says that laboratory tests and forensic reports are not exempt from the confrontation clause, as they are subject to manipulation or human error. To protect from this fallibility, a defendant may cross-examine an analyst by asking about the tests the analysts performed, the risk of error presented in the test, and an analyst's proficiency in interpreting the test results. Where one individual actually performed the lab work and created the applicable reports, a surrogate expert witness who merely reads that other individual's output violates the confrontation clause. So again, ultimately, that's the theory upon which the court relies. The court goes through a number of cases that Justin talked through back on episode 259. The court goes through the United States Supreme Court decisions of Smith versus Arizona, Bullcoming versus New Mexico. It goes through some of the state decisions of State versus Ortiz, Zappe of State versus Lester, State versus Craven, all of which Justin talked about back on episode 259. So again, they do the full analysis. There's a question of whether the testimony in this case and the report that was produced by analyst Alcox was in fact testimonial hearsay. Was it offered for the truth of the matter asserted, and was it prepared for court purposes? Ultimately, State versus Holt, the court answers yes to both of those questions. And I think anytime that you have a state crime lab result, or a forensic test that is performed, that is going to be the appropriate conclusion. Just briefly reading here, State versus Holt says North Carolina courts treat lab reports created only to assist in police investigations as testimonial. Again, I think that's going to be true, if we're not talking about hospital records, and I'm not saying that hospital records necessarily don't qualify under this, but if we're talking about a state crime lab or any type of, crime investigation unit that is performing the analysis, I think you've got a State versus Holt argument, Smith versus Arizona situation all day long. One of the, again, reading from some of the language of State versus Holt, the court, really dives into the question of credibility. And, we're just accepting the credibility of the substitute analyst that did not have the ability to actually look at the blood, who is then just being the mouthpiece for the actual analyst that had the opportunity to look at the blood to potentially cause human error in the testing results. And so the court says the jury cannot decide whether the expert's opinion is credible without evaluating the truth of the factual assertions upon which it is based, as the defendant is entitled to the opportunity to challenge the veracity of the out-of-court assertions that are doing much of the work. Further down, in other words, the testifying expert analyst effectively becomes a mouthpiece for the analyst who created the report. The court says that this is not allowed. The Supreme Court of the United States in Bullcoming versus New Mexico held that because the substitute analyst could not convey what the original analyst knew or observed about the particular test and testing process he employed, nor could expose any lapses or lies on the certifying analyst's part, the confrontation clause was violated. Again, further on down the opinion, in this particular case, Dr. Wagner testified he likely did not ever see the defendant's blood sample with his own eyes and did not personally know the condition of the blood. As a result, again, further down the opinion, defendant was unable to question Alcox's potential human errors, including his observation of the condition of the blood sample for possible clotting, fermentation, pipetted bubbles, or homogeneity in the blood sample, confirmation of the sample's sufficient blood volume, and examination of packaging mistakes or vial leaks. So again, I think that this opinion, which ultimately said the testimony itself of Dr. Wagner and the introduction of the analyst's report, that is Alcox's report, violated the confrontation clause is clear. It's extremely clear. So if you have a situation where you have a substitute analyst testifying, and one thing that I will say, just as like a side note, most of the time in the alcohol related testing, there's one analyst doing the testing. So, substitute analysis is a little bit easier to identify because it's like one person did the blood testing, and now you've got a second analyst that is coming into the courtroom to testify. As Justin spoke about back on episode 259, this problem becomes accentuated when you get into drug blood cases, because typically if there are multiple substances that are found in a client's system, in the case of a drug blood analysis, there are often multiple analysts that are conducting the testing because of the use of batch testing at the state crime labs. So you may have multiple analysts that are actually involved in testing for various specific substances on a blood drug case. So you've got to be also aware of this issue, because it's actually probably more prominent potentially in a drug analysis than in a alcohol analysis. So ultimately, how does the state potentially fix this going forward? Let's say that you have a analyst at the crime lab that leaves. Well, either the state can subpoena that analyst, follow them wherever they have now gone in the next stage of their career, or retirement, or whatever it might be, or somebody else at the state crime lab can basically reconduct testing. Those appear to me to be the two options that the state would be to have somebody basically retest the blood results. And again, I don't know that doesn't then further create problems, because it's kind of like, well, you had this analyst that had a kind of was getting down and dirty, so to speak, with the blood sample originally, and now you've got somebody else that's coming in to do a second sample. So how do you identify any issues that could have been caused during the first analyst's testing procedures and process? So that may create like a whole other can of worms. But I think that under State versus Holt, that's the only solution to fixing the problem. I think that we've kind of, again, been in muddy waters a little bit, as Justin explained, with substitute analyst testimony. Craven and Ortiz-Zappe seem to be somewhat at odds with each other on this particular issue. And I would say State versus Holt very clearly clears up the muddy water. I mean, it's a clear decision that substitute analyst testimony is going to likely create issues for the state in the ability to use a substitute analyst to testify, or to get in the original analyst's report without that analyst being able to be cross-examined. So again, State versus Holt, very, very strong decision from the North Carolina Court of Appeals. Definitely go in, do a deep dive, read of it, be ready to present that as needed on blood analysis cases. Hope this information has been helpful, and look forward to speaking with you again next time.